What have been the issues, and what issues were accepted by the inspectors and the public interest at stake, as well as community impacts?
Right, okay. It's natural to ask what the issues were and are. I think what dawned on a lot of people in the course of the 4 phases of consultation that EDF held, issuing reports about issues and so on and so forth, before we got to the inquiry and then to the inquiry, is that the result of the changes to planning law, the 2008 Act, was that the issues were, for the first time, very, very clearly, though they were very complicated, defined by public policy, not by, if you like, the natural responses of the communities affected. So the 3-year public inquiry that created B was actually an open-ended public inquiry, and there were 10 or 12 volumes of evidence and so on, and anybody can go and say anything. In principle, anybody could go to the inspection process, which took 6 months online during COVID, and say what they liked. But the process was very, very different to the public inquiry. So one of the issues that the campaigners had to face was how to influence the very formal agenda of the inspectors, who were there to make a judgment about whether the project was lawful or not, and whether it was lawful in terms of breaching environmental law or damaging nature, or lawful in terms of being in line with government policy decided by Parliament and government, which is a different matter. So a lot of people appeared in front of the inspectors, and I don't know about public inquiries, but I think they're reasonably open, and the inspectors do sometimes talk to people and have a dialogue. But basically the inspectors listen to presentations and formally invite the developer's law firm, as a very senior barrister, headed it up. He had probably a backroom team of assistants of about 10 people, who would brief him while he bought a bit of time, and then on the screen prompt him with very technical answers to regulatory questions about construction, environmental impact, you know, whether you're allowed to run railways at night and so on and so forth. All the technical stuff was part of it, even though the inspectors did allow people simply to say the impact on our villages of 10 years of 700 lorries a day coming down narrow lanes is going to be impossible. I won't be able to get my kids to school and so on and so forth. Another dimension of it, which gets between the communities having a chance to express their worries and the question of whether the project as proposed was going to meet policy and law, was the role of the public authorities. And all the blue light people were called in, the police were called in, the ambulance service, what would happen if there are accidents and so on and so forth. And a lot of the time of the inquiry was taken up with formal presentations about whether the authorities actually had the resources to cope with the building, and also who would be responsible for any impact, not just during the building, but later on, should there be an accident. You know, the background to all of this being the very big nuclear accidents in Russia, China and then Japan, the 3 big ones which have really put the world nuclear industry on the back foot. So there were 3 sort of agendas running in the inquiry. What we tried to do, to the extent there was coordination by the campaign groups, was to think of the issues that we were worried about, and they expressed them in planning language for the inspectors, and where there was a question of technical professional questions, to find people in the community who had some form of expertise which could challenge the assessments that all the time were being, they've been put in the consultation documents, but were then put forward by the QC on behalf of the company. So the name of the game was to find an issue, a definition of an issue, put it in planning terms, and say this project will not work because there is no water, which was an issue that eventually became very, very important. And hear what the developers said when the inspector said, what is your answer to the water supply problem? The inspection process was itself very complicated, but what we did achieve, I think, was getting a much broader agenda in the planning inquiry than would have been expected. So we got funding issues involved in it, which technically are not planning issues. They're simply to do with government and, at the end of the day, the electorate, you know, people prepared to pay for a big expensive project like this. We got a lot of it into the inquiry, which you could argue wasn't decisive. It wasn't going to defeat the project, but it did actually change the description of the project and the popular understanding of the implications of it. And a way of expressing that is to say that the approach of the public authorities, that's our Suffolk East, as it was known then, District Council, and Suffolk County Council, and many other people, and sadly including the RSPB, tended to be, what can we get out of this as mitigation money, compensation money, because we're not going to stop it, because government want it and policies in favour of it. That was where a lot of the politics rested. And in the case of the RSPB, the Mindesmere local people were very good, campaigned, held public events and so on. But at a legal level, RSPB nationally basically did not put up a strong case and had a side agreement, these are, they're called statements of common ground, where compensation has actually been agreed. The compensation, I think the total sum involved in compensation, in financial compensation, runs to the order of about 250 million. But the development cost of the whole thing has been 500 million and over before a single bag of concrete, you know, is mixed. So the project is really quite massive. The legal costs have probably been quarter of, 250 million pounds. Navigating, to use, if that's a term people understand, navigating the politics of the law and the different interests and trying to find how a community voice could fit into that was really what the challenge was. The good thing was that in Suffolk, with so many retired middle-class professional people, there were people who were actually good at, knew about coastal erosion. There were people who knew a lot of ecology. The group I was involved with, we did a lot of research on planning judicial reviews. There was quite a professional input by various campaigners, and there were some quite senior people who also, from drawing on their own experience in commercial life and professional experience, also said this is a bad project and it will not work here. There was no single instrument which you could say would be decisive in the process. And in the course of it, this is where the time factor becomes very important, government itself changed its policy. And the essence of the situation is that government policies are now called National Policy Statements, NPSs, and the NPSs are all subject, because they go through Parliament in a very mild way, they're all subject to time limits. So there's a family of 6 of them in the energy sector, which is all mixed up with climate and building national grid and so on and so forth. All of those were being reviewed while this process was going on. So government itself had created, if you like, a legislative background, and also with Brexit they're now trying to change a lot of the European regulations, but Europe has got a lot of jurisprudence, you know, very, very European Court of Justice cases about environmental protection, all of which created a context for it which made it very, very difficult for anybody to be very decisive. One of the big strains on everybody campaigning was thinking, how do we get this across and get it taken seriously, and really is it part of the process? To be very, very concrete, the funding issue is very important. What did emerge in the process was that the government intended imposing a levy on everybody's electricity bills to pay for it if the private money and EDF couldn't afford to build it. And it was there's a financing model called RAB, which is
regulated
asset base approach, which has been used for the new sewer under the Thames and at one airport, and people are, you know, pretty iffy about. But the intention was there would be a levy hidden in our electricity bills of a few pounds a month to pay for this nuclear power station. But there was also the worry that the government originally, Blair and Brown and Cameron, envisaged having more than 20% in future of Britain's electricity coming from nuclear. Well, that was some time back. What is now very, very clear is that if Sizewell is built, which I personally doubt, I don't think the money's there, the next generation wouldn't be great big European pressurised reactors at all. I think it's been realised that they are too big, too expensive, they're not flexible and all sorts. But now the public agenda has shifted to small and medium reactors, which is a totally different sort of area of economics and technology. So if you ask what the issues are, I think my judgment would be that the powerful issue should have been, is this a practicable project on the A12 road, which is going to take 700 lorries. For 3 years we'll now have to take water bowsers to provide potable water to mix the cement for 3 years while they build a salination plant on the construction site.
Diesel.
Towards the end of the project there will have to be another salination plant built within the plant itself. So the 2 salination plants have emerged in the process of understanding. But I think the impact assessment which the community wanted was that this is not going to work. The traffic will be impossible. Towards the end of the project we found out that the mix for the concrete is a special form of aggregate, and that has got to come by train from the West Country all the way across Britain, round North London, and all the way up on 4 freight trains at night on what is really just a local railway system. So a lot of impact issues the community got right originally. Subsequently